Hey, beautiful people. On the note of acting judges and matters where we find ourselves in front of them, too often many people will find that when it comes to proceedings, it won't take too long for one to realize that the issue itself is not the subject matter. The issue itself is not the opposing party. The issue itself usually arise from the one who's supposed to be acting as a neutral third party, as a referee. So most people will find themselves in a situation where they are actually battling the acting judge himself or herself. They will find that the one that they're engaging in the interaction with is the acting judge. It ought not to be like that. See, when most people learn about pen and paper, what they will find is tools that are retroactive. But the setup to activate that tool, most people don't know. For instance, the issue of default judgments. See, a default judgment occurs after a contract or performance has not been performed, but very specific to the essence of calling someone to do something. And when they don't respond where they are obligated to, then they are in default. And that calling forth of someone specific to default judgment is called summons. Default judgments in the realm of legalese is used specific to summons. Summary judgments are used to do the same thing default judgments do, but regardless of the circumstance. Like habeas corpus, on the other hand, it's used to show the constitutionality, to show the law as to why someone is being held. Because habeas corpus is a type of constitutional challenge, but specific to someone who is detained. Whereas there is a constitutional challenge of its own that is not specific or limited to the circumstance of detainment. So there's always a corresponding aspect to tools, whereby there's a specific aspect of it, and there's one that can be used generally. When it comes to holding people liable for not behaving, default judgment is the confined one specific to summons, whereby if you don't respond, you forfeit it. Default judgment and forfeiture is the same thing. Whereas summary judgment does the same thing, but in a broader sense, regardless of whether it's specific to summons or not. Habeas corpus is specific to people who are detained. Habeas corpus is a type of constitutional challenge, but a constitutional challenge separate from detainment can still be used. So there are tools that exist whereby there's a limited aspect of it and there's a broad aspect of it. And the way you use it will determine how it will be entertained. On the note of recusal, judges to recuse themselves. Most people try to do something like a default judgment. I ask you for your oath, you're doing this, and you're in default. The moment you begin to do that, you basically set a pace that's not beneficial to you, rather than actually knowing how the operation of how to get an acting judge to step down works. The operation of how to get a acting judge to step down, how it works, is what we'll go over. To recuse, to disqualify oneself as a judge in a particular case. To remove oneself from participation to avoid conflict of interest. There are two ways an acting judge can be recused. The first is that weight and swing it and slap them with it. And casually carry on that weight and go by your way. No matter what wrong they do, since you have a right, it is your responsibility to make things right, regardless of what venue you're in. It is up to you. Fifth Amendment. No person shall be deprived of life, liberty, property without due process of law. Nor shall private property be taken for public use without just compensation. Private property Now you see the importance of doing the non-UCC and doing the copyright and coming in through a trust. If the acting judge intends to, on a state level, that they statutize is, well, we know you have speedy trial right, but if there's any question about your competency, that gets put into abeyance. Or we know we're supposed to extradite you within 30 days, but if there's any local case, we're not going to extradite you and we'll just put that into abeyance. Or we know that you have the right to be secured in your parishes papers in effect, but well, there's a dispute on property that we're not going to make it very clear that we have interest in it, and we are basically construing through our trust, and this is really a property dispute unless you bring it up that it's a property dispute. Then, well, we can delay everything because we also have interest in this and its legacy, and we're making money off of it. But in the note of speedy trial, every person ought to find a certain remedy in law for injuries or wrong, which he may receive in his person, property, or reputation. He ought to obtain by law, by right, and just freely without being obliged to purchase it, completely and without denial, promptly, without delay. Literally, you can go to the Bill of Rights in any given constitution. You can look at anything that's been said, which is the what, and then you can take that what and you can implement. Is really not for you. The show cause for it is actually for them to afford them due process that, okay, someone in this case so when a lot of people say something is legal but cannot be lawful, or something is lawful and cannot be legal, though, that's just another rhetoric that confuses people. Legal is literally just the medium to which law is enforced. Law is the what, legal is the why and how. That which is according to law. Meaning, if the entire 54-minute video is on the Patreon page. Take care. Best of luck.